The views and opinions expressed on this program are those of the participants and do not reflect the views of BronxNet or the program underwriters.
BronxNet. Your voice, your views, your vision.
You have a few drinks and get behind the wheel. You might think it's no big deal and the penalties can be dealt with, but you are very sadly mistaken. You will have a rude awakening, and on today's show, you will find out why getting behind the wheel when legally drunk is a costly decision. It is an important show, so stay right here because today's verdict starts right now. Welcome to today's verdict, the show that gives you your legal rights and options. I'm your host and trial attorney for the next 30 minutes, David Lesh. Every year in the United States, nearly 10,000 people are killed in crashes involving alcohol-impaired drivers. Recent statistics suggest that more than 173,000 individuals are also injured, with 27,000 suffering incapacitating injuries. These alarming numbers propelled the National Transportation and Safety Board to issue a report containing 19 recommendations that call for stronger DWI and DUI laws. The recommendations demand swifter enforcement with expanded use of technology, including ignition interlock devices. The ultimate goal for implementing the recommendations is to reach the number zero. That is, to reach a zero number of alcohol-impaired driving crashes. Although these are only recommendations, the NTSB is urging state lawmakers to consider mandating these recommendations over the next few years. Let's listen to NTSB Chairman Deborah Hersman as she comments on the report.
As many people in the United States believe that we have solved the drunk driving problem, but in fact that is not the case. We lose on average of 10,000 people to impaired driving crashes every year. We lose 173,000 people to injuries in those crashes. 27,000 of those injuries are life-altering, debilitating injuries. This translates to one fatality an hour and 20 more injuries every hour. We have not solved this problem. We have recommended a targeted set of interventions in our report today that will prevent crashes, reduce injuries, and save lives. The recommendations are focused on stronger laws, swifter enforcement, and expanded use of technology. The United States is used to leading when it comes to safety in transportation. But in this area, we are woefully behind our international counterparts. The NTSB makes our recommendations based on facts, based on the data, and based on scientifically supportable information. What we know is that we have seen overall reductions in the number of fatalities when the United States went from a 0.10 blood alcohol content to a 0.08. We know that we've seen significant reductions, not just in low BAC fatalities, but we've also seen reductions in the high BAC fatalities. It has the effect of everyone drinking less. We've also seen reductions in other countries that have gone from an 0.8 to an 0.5, Europe and Australia. We have seen reductions in the neighborhood of 5 to 15%, depending on what study you look at. What we do know is that where drivers were tested and BACs were identified, there were almost 1,000 fatalities in the United States in 2011 involving drivers who had a BAC between 0.05 and 0.07, which is below the legal limit. It's about employing things that we know that work across the board, about getting better penetration, about getting stronger laws, swifter enforcement, and expanded use of technology. We need to see action at the state level. We need to see action at the federal level. And we also need to see action when it comes to industries and organizations. And finally, the most important action that can take place is that action that occurs at the dinner table, at the restaurant, at the party. And it's the decisions that each of us make individually. It's about having a plan when you're drinking and not drinking and driving. We make many recommendations. Many of those recommendations take time to implement, and we understand that. This is really about changing attitudes, changing culture, changing what's acceptable. In 1983, Oregon and Utah were the first states to move to .08. They led the way. The rest of the country followed. Some states didn't come along until they were forced to. We know that change will happen. What we'd like to see is for that to accelerate. We don't want to be here looking back 30 years from now saying, could we have done more? Could we have saved 300,000 lives and prevented millions of injuries? We have got to take this issue seriously. It affects all of us.
Joining us in studio to guide us through the complexities of New York's DWI and DUI laws is attorney Joseph McCormick. Mr. McCormick is the chief of the Vehicular Crimes Bureau of the Bronx District Attorney's Office and is responsible for the training of prosecutors and law enforcement statewide, and we are lucky to have him on the show. Counselor, before we get into the regulations themselves, let's start from the beginning and talk about the present sense of DWIs in New York. Where do we stand right now?
We've been lowering homicide fatality rates in DWI crashes for a long time. When you look at years ago, it used to be almost 67% of any fatalities in New York State were alcohol-related. Now we're down to like about 33%. So we've been doing good, but the last 10 years have been a stagnation. That's really what they're talking about at NTSB, is that we haven't changed it in a long time.
All right, now, what are the elements here? Let's say somebody is picked up for DWI and you're going to prosecute the case. What do you right now it's presently .08, am I correct? Mm-hmm. Is that a misdemeanor? Is it a felony? Where are we in the courtroom?
08 and above is a misdemeanor in New York State, so it's punishable by, it has a mandatory fine structure, it has a mandatory suspension of your license for 6 months, it has a mandatory interlock, has to be put on your car, we'll talk about it, I guess, later, and then it also has the potential of jail up to a year.
Now that's driving while intoxicated, am I
right.
correct? And how does that differ with respect to driving under the influence, which are two different aspects?
I think of them as driving impaired.
Okay.
You have driving intoxicated, driving impaired, and driving impaired is not a misdemeanor, it's a violation. So the penalties are somewhat less.
Now, if you were stopped and you blew a certain level, let's say .06, mm-hmm. right? Is that driving under the influence, or is that DWI, or is that both?
At 06, the officer would have to see impairment. He would have to be able to articulate that there's something about you that shows that you're you're impaired, that alcohol has affected your ability to think, to drive, to act. At 07, the law says pretty much prima facie you're impaired.
Now, you've been doing this for a long time. Is it on the rise in the Bronx? What do you see? Are more people driving while impaired or intoxicated? Both? What's your impression?
I see really what the national view is. You see, I've been doing it a long time, David. That's very, very true. And in the early years, arguably there was more, and arguably it was more dangerous. You had more fatalities. But I still sit in my office virtually every week, and I have a family come in who's lost somebody to drunk driving, that we have to talk about their case. And that's been very consistent for the past 7 or 8 or 10 years. And that's why you're seeing these kind of proposed changes.
Well, let's talk about the changes and your feelings on them. I'm sure you have an opinion. What is your opinion concerning dropping the level from 0.08 to 0.05?
Well, you have to look at where the science, this is one of those places when you just talk about the number where the science intersects with the law.
Okay.
And so 08 was based upon a thing called the Cedar Rapids study, which showed that your likelihood of being involved in a crash was much higher from 08 on. But I've also seen studies that talk about how discernible impairment happens when a person's as low as an 02 or an 03. And we see that. Anybody who's ever drank a beer at the end of a long, hard week knows that just having that one cold beer has an effect on you. It may not be a terrible effect. It may not make you an unsafe driver, but it's a discernible effect. And
well, that's the reason we have the beer, so we can have an effect on ourselves. Else we might not have had the beer to begin with.
Right. And that one beer isn't going to really make that much of a difference in the numbers. They say about a 0.2 for a 180-pound man. And so you'd still be below all these numbers pretty safely.
But it would make a difference if you were a 120-pound woman who had that one beer. Because from what I'm reading, that one beer is it. You can't have even another half a beer. That woman would not be able to drive if she was if that was 0.05. So, I mean, there's a sense of fairness here, I guess is what I'm trying to say. And I can understand how some people on the other side are suggesting, hey, wait a second, I don't want to be limited to one glass of wine. How would you answer that, somebody else who makes that?
Well, how many do you want to be limited to? Like, that's really the problem in a nutshell. A 120-pound woman, one beer is not going to be an 05. But we don't sit around, regularly discussing, okay, exactly how much can you drink until you hit the magic number? Because the problem there is that the one beer makes you feel good, and the second beer or drink might make you feel better. And it also starts to take away your ability to discern the idea or the benefit of having that third or fourth or fifth. And so that's where you see this 05 come in. Is what you're talking about is as the director of the National Transportation Safety Board said, you're talking about a change in attitudes. A change in attitude of no amount of alcohol is really acceptable if you're going to turn the key in the car.
But Joseph, let me ask you a question. When you prosecute these cases, do most of the blood alcohol counts that you're involved with, aren't they over 0.1? Aren't they usually 0.12, 0.13 anyway? So if the people who are committing these crimes and driving while intoxicated are blowing over 0.1, well, what's the difference? You're not really looking. You're looking to get those people. You're not looking to get somebody who's only going to blow 0.05.
Well, the thing is that actually some of the numbers that I've seen, David, are even higher than that. That if you run the median of our cases, take 100 cases and look and see where the number flows, it's actually a 1.6.
Really?
It's a 1.6, which is twice the legal limit, which is pretty scary. But the way they get there is that there's always that first one and the second one and the third one, those drinks, and that reduces their judgment and their thought process.
Hold on a second.
So that's what this is. This is to change attitudes. Remember when there used to be smoking in bars?
Absolutely.
And now there's no smoking in bars. It's not so bad, right?
Not so bad unless you're a smoker.
Go outside.
And you want to smoke in the bar. That's a little bit different. Okay, let's get back into the courtroom now, because let's put your hat on. You got your prosecutor's hat. How do you prosecute a case? How do you prosecute a DWI case? What if you don't have a breathalyzer? What if somebody didn't blow? What do you do? How do you do it?
You have two things to prove in a DWI case. You have to prove the person was operating a motor vehicle, and that's usually a police officer sees it, or you have an admission after a crash. There's some usually pretty easily definable way to show that the person's driving the car.
Okay.
And then the second part is drunk. Driving while you're intoxicated. The second part is show intoxication. It can be through observations of the person by the police officers. Your mother knew in high school when you came in and you had too much to drink. You can look at somebody and you can say, they've been drinking and they've been drinking too much. And so that's what police officers often rely on. And then on the other side of it is we also put them on instruments. We put them on breath testing machines to tell.
Well, we're going to have you back a little bit later on the set, and we're going to debate this with the defense attorney. But right now we have to take a quick break. But when we return, we will investigate a new technique being used by defense attorneys as they take on a DWI charge. We'll be right back.
Did you find the flashlight and the batteries?
Yes.
Did you make sure we're not missing anything in the first aid kit?
Yep.
Did you go through the plan with the kids again?
Yes.
The more you prepare today, the more you'll be able to reduce the devastating effects of a tornado, an earthquake, a power outage, or any other disaster.
Sir, are you okay?
Everything's fine. Thanks.
You wouldn't ignore this, so why ignore the signs of a stroke? Call 911 immediately, because time lost is brain lost.
Welcome back. I'm your host, David Lesh. We have been discussing DWI and DUI laws in New York from one side, that of the prosecution. But at today's verdict, we know there are always two sides to a story. Our next guest is attorney Stephen Epstein of Barquette, Marion, Epstein, and Kieran. Mr. Epstein has over 21 years of experience as a criminal defense attorney, handling cases that range from your basic traffic ticket all the way to the charge of murder. He has recently co-authored a book titled Strategies for Defending DWI Cases in New York, and he's here to shed light on the role of a defense attorney when it comes to the crimes of driving while intoxicated. Mr. Epstein, it's nice to have you here.
Thank you, David.
All right,
Nice to
so
be
I
here.
got the other side of the story right now. Okay, I'm sure you're not thrilled with the regulations, are you?
Well, the regulations, in my opinion, David, cast too wide a net in the wrong direction. The goal of reducing vehicular homicides, vehicular accidents that are related to driving while intoxicated is obviously a sound one, and there are many things that we could do. The recommendations of the NTSB as they relate to the ignition interlock and some of the other provisions are sound. The proposed reduction of 0.08 to 0.05, however, is one that I don't agree with.
Okay, well, I feel it's easier for me from this position to be able to debate, because the statistics do show that when these particular regulations have been adopted in other countries, certainly the rate of death has decreased. And I can't see how there'd be really a debate as to why we wouldn't want to prevent more deaths or more injuries. So how do you answer that?
You have to make a decision as a society, the important concepts of society and what you want to prohibit. DWI at its base, as a common law statute, as a DWI driving related offense, dealt with prohibiting somebody from operating a motor vehicle while their actual ability to operate the motor vehicle was substantially impaired by alcohol. It started in England, and New York State was the first state in the United States to enact DWI statutes. At its core, it was about drunk driving. You shouldn't operate a car while your actual ability to operate that car is impaired. New York's current statute, VTL 1195, clearly states that driving with a BAC, a blood alcohol concentration of 0.05, is prima facie evidence that you are not impaired. In other words, that your ability to operate a motor vehicle is not impaired by alcohol. What this relates to and what this stems from is more of a political decision. The per se offense, the current 0.08 offense, was just adopted and came about in the United States in the 1950s with the advent of the breathalyzer. It became a tool or a means for the prosecution to prove their case. It became easier. So it's a political type of crime. The person that they're getting from a 0.05 is not the person that you're aiming towards preventing these accidents.
Well, you tell me, what person is walking into your office?
Well, the person that's walking
Is it the 0.05? Is it the 0.13?
As A.D. McCormick indicated, the average person that's getting arrested on a DWI case who submits to a breath testing device is much higher than the 0.05. And the average person that's coming into my office is a person who's never been in the criminal justice system before. You have to realize the type of crime that's at stake here. You have doctors, lawyers, architects, engineers, people in the medical profession, people who never otherwise would be involved in a criminal offense. And the collateral and the direct consequences of a DWI case are extremely severe. Now here's my concern ultimately with the 0.05. This device, and in New York State we use breath testing as the predominant measure for measuring blood alcohol concentration. You can do blood tests, but in New York it's very rare, other than an accident that involves serious injury or if an individual is taken to the hospital for some reason. Predominantly, it's a breath testing device. David, the best answers come from knowledge, not numbers. When you quantify anything, measurements are always uncertain. In fact, in New York State, the Department of Health has a regulation that says that there's a range of error of the breath testing device of 0.01 in either direction. So your 0.05 all of a sudden comes down to, could be an 0.04. The problem is that's not the only variable. There's temperature variables, there's breathing variables.
Temperature of the person's temperature
exactly,
inside body temperature or the outside world
No,
temperature?
the inside, the breathing. Because you're talking about an indirect measurement to calculate blood alcohol concentration, not by taking blood, but by taking breath. What you're getting is you're taking this 0.05 and easily could be prosecuting somebody that's an 0.4, 0.3, 0.2, depending upon the blood to breath ratio of that individual. What we presume in breath testing is that there's a ratio of 2,100 to 1, that an individual's breath blood alcohol content to its breath alcohol content has that ratio, but it's not a one-size-fits-all.
Okay, well, let's talk about your book, too, because
Sure.
you obviously know how to defend a DWI case. You do it all the time. Strategies for defending DWI cases in New York, right? Tell me, a client comes into your office. You got to start preparing your defense. What do you do? Do you witnesses? How do you start? How do you even begin with this?
There's two different kinds of cases. You have a breath test case and you have a refusal case. Those are the two general categories of offenses. And they are completely separate animals. The key with a breath test case is to find something in the science, something that happened either with the machine intrinsically. You want to take a look at all of the calibration records, all of the maintenance records of the machine, if possible. And here in the city of New York, the actual breath test is videotaped. You want to take a look at how the breath test was done, and you want to also examine your client's background. Are they diabetic? And if they're diabetic, there's a potential problem with the result. Were they on a high-protein diet? Were they exposed to anything that could elevate their BAC?
Well,
So that's that
give
side
me a
of it.
percentage. What percentage would you say that you were able to show fault in a device?
A device or the way it was used in New York State, very often. I'll tell you why. Because first of all, the first problem in New York State, and one of my concerns with the reduction to 0.5, is New York State is a single test state. Everybody knows you measure twice, you cut once. I've heard that term before, right? Yes. In New York State, we take a single sample. In most other states, you have replicate testing. And then what between those two tests, they have to be within a certain degree of one another. All of forensic toxicology, if you look at the SOFT guidelines, which is the standards of forensic toxicology, and you ask any other toxicologist, they'll tell you integral to any measurement is replicate testing. We don't replicate test in New York. So that's the first problem that you're going to have with any case that you're dealing with a breath test in New York State. Fundamental. Also, when we calibrate the devices, when the police department measures it to see if it's operating appropriately, they only use a single sample. They use a 0.10 reference standard. Well, that tells me the machine is working right at 0.10, but it doesn't tell me if it's working right at 0.5. So there are lots of different things that you can do in every case. And then with every case, there are also things particular to that case.
All right, well, just again, I want to mention your book, Strategies for Defending DWI Cases in New York. A good read. Don't go away. We're going to have you back. But right now, we have to take a quick break. But coming up, we will ask our legal experts what is their opinion about the NTSB's proposal to lower blood alcohol levels nationwide. We'll be right back.
Welcome home, man.
Welcome back. I'm your host, David Lesh. Remember that our show is here to serve you, our viewers. So don't forget to connect with us on Facebook at www.facebook.com/today'sverdict and on Twitter at Today's Verdict. And tell us what topics or questions you'd like us to cover on the show. We've been discussing DWI and DUI laws here in New York State, specifically how the NTSB's 19 recommendations could change how we drink and drive. One major change is the lowering of the legal blood and alcohol level from 0.08 to 0.05. Now the question is, will the lowering of the BAC level decrease the number of alcohol-impaired accidents, or is it just another government intrusion that prevents you from having one glass of wine at the dinner table? Here to share their legal expertise on the matter is the Chief of Vehicular Crimes Bureau of the Bronx District Attorney's Office, Attorney Joseph McCormick, and Criminal Defense Attorney Stephen Epstein. Mr. McCormick, I'm going to get back to you because I'm intrigued with whether or not this breathalyzer fails or doesn't work or malfunctions. Is that a valid defense that you've been hit with, or no?
Well, Steve is giving us an awful lot of trade secrets there, huh? Telling us everything we need to know. Those instruments are tested by the National Highway Traffic Safety Administration. They're tested by New York State Department of Health. They're tested by the police agencies that purchase them and put them into service. They're tested over and over and over and over again. It's really kind of mind-boggling how much they're tested. They're used everywhere in the country. They're used everywhere in the world. I don't think really we'd be doing all that if they just didn't work.
But Mr. Epstein has a point. Where do you draw the line? 0.08, 0.07, 0.05. Today I'm okay to drive. Tomorrow I'm not. When do we know where we're going in the law when it comes to this particular issue? And I think we as a society have a right to know, where we're heading. What would you say to that particular argument?
The entire concept of DWI enforcement has to do with changing behavior. The reason why, if you get arrested for DWI and you get convicted of it, and it's fines, it's punishment, there's a lot of trouble, is to get you not to do it anymore. The whole concept behind DWI enforcement is to reduce injuries and deaths. And if you have less people driving drunk, you're going to have less people getting hurt by people driving drunk. And it's worked in the past. So what you're looking at with this 05 is just another way to lower the overall instance of people driving drunk.
Okay, Stephen, getting back to the breathalyzer. Mm-hmm. Let's say you got what you wanted, and you had 2 bites of the apple, should we say. One test, second test, within a 5-minute period. And you got something right in the middle. Would that satisfy you in terms of your ability to use the device?
The replicate testing is instrumental, and it's something that the government absolutely should be imposing. It's not just the machine, it's how the machine is used. So you need to make sure, for example, here in the Bronx at the Intoxicated Driver Testing Unit, they have a Purell dispenser on the wall. Purell contains alcohol in it. It shouldn't even be in the room. So it's not simply saying the machine is good enough and it should work. The machine is on the National Register for approved devices, right? So the machine itself, the fundamental principles of the infrared spectrophotometry of the machine work. It's not a question of whether the machine works, it's how it's used in each individual case. You could take a baseball bat that's used by Derek Jeter and another player picks it up who doesn't quite have his skills. He's not going to hit the same batting average just because he's using the same bat that Derek Jeter used.
Derek Jeter's not doing particularly well right now because he's not playing. But I understand the analogy.
So it's more than just replica testing.
Yes.
But replica testing is principle at its core. There should be a calibration curve, and there are jurisdictions where there are calibration curves. For example, in the state of Pennsylvania, it's actually by statute that the machine has to be calibrated between 0.05 and 0.15, and it accepts everything within that range.
Well, I have to tell you, this is one issue that's not going to go away. I'd love to see both of you in the courtroom at the same time, and hopefully you two will come back so we can discuss it further. Agreed?
Anytime.
Anytime.
Agreed. All right. Well, that's all for tonight. It's time to deliberate. I'd like to thank both of our guests for joining us, and of course you for watching. Remember, if there's a legal issue or topic you would like to see on the show, email me at davidlesh@bronxnet.org. And until we see you again, always remember, know your rights, know your issues, reach a verdict. We'll see you next time.